A very warm good morning to all of you. Dear students, once again, I would like to welcome all of you to a new session of the Civics class. Today, we are continuing the same chapter from Civics, chapter number 4, the Supreme Court, part 9. Do you remember what we were discussing in the last class? In the last class, we were discussing about functions of the Supreme Court and the different ways used by the Supreme Court in the settlement of disputes. So these were the two different points which we were discussing in the last class. And today we are going to discuss the remaining two jurisdiction. First one advisory jurisdiction and second one revisory jurisdiction. So we are going to study something further about advisory jurisdiction and revisory jurisdiction. Let's move to the class without wasting time. Advisory jurisdiction. Advisory jurisdiction simply means to give its opinion. So Supreme Court has got the power to make or to give any kind of opinion if it is necessary. Okay? On any question of law or fact of public importance as may be referred for consideration by the President. So, if the Supreme Court has to give opinion, there is a condition. What is that? It must be something related to the law on any question of law. The Supreme Court has got the power to give its advice. Fact of public importance as may be referred for consideration by the President. And it must have some public importance, and even the President also wishing that the Supreme Court must give a few comments or remarks regarding a particular law. So that's what is meant by advisory jurisdiction. As we see, advisory means to give its opinion. So Supreme Court will be giving its opinion time to time. So it is not something like a new law, but it is just an opinion. It can be classified into two matters, or in two classes of matters it has got divided. First one, question of law referred if the President considers it is of public importance or it is necessary to obtain the opinion of the Supreme Court whenever it is needed. So, first of all, the President must concern about it. Okay, President has to consider it. Or in other words, any question of law may be referred to the Supreme Court if the President considers that the question is of public importance and it is necessary to obtain the opinion of the Supreme Court. So I think it is very clear to you. So first of all, the President has to refer it to the Supreme Court. And if he has to refer on a particular law, it must have some public importance. Okay? And again, the President must feel that it is necessary to obtain the opinion of the Supreme Court. So by the time the President will approach, or the President will ask the opinion of the Supreme Court, and the Supreme Court will definitely convey its opinion regarding that particular issue. And such opinion, it is advisory. Okay, so this kind of opinion which is being communicated or given by the Supreme Court by President is being known as advisory. And second one is disputes from pre-constitution treaties and agreements which are excluded from original jurisdiction. So second type is disputes from pre-constitutional treaties, which means you might be remembering our constitution came to exist by 1950, and before there were number of treaties and agreements. So if it is a disputes regarding those kinds of issues which are excluded from original jurisdiction, in such cases also the Supreme Court can convey its or express its point of view or its advice. So in the first case, we have to consider one more thing. We have seen it is of public importance or it is necessary to obtain the opinion of the Supreme Court, and such opinion is advisory. Along with the one more point we need to remember, such opinion of the Supreme Court is advisory and not binding on the government, nor it is executable as a judgment of the Supreme Court. I will say once again, such kind of advice given by the Supreme Court, it is not an obligation. It is not obligatory, or it is not binding the government. It is not stopping the government from doing something, but rather it is just an advice. Okay, so such statement is given by the Supreme Court doesn't mean that the government has to stop its activity and they have to implement what the Supreme Court told. But it is simply like putting a light into something, or in other words, it is just to remind the government regarding certain points. That's why we say that it is advice, not obligation, or not executable, or it is not a judgment. So this is what is meant by advisory jurisdiction. And now we move to the next one, that is revisory jurisdiction. According to Article 137, Supreme Court is empowered to review any judgment or order, to remove the mistakes, if any, that might have crept in the judgment or order, because Supreme Court is a court of record. So according to Article 137, Supreme Court has got ultimate power to review any judgment or order made by Supreme Court as well as other courts. And this particular concern is given, or authority or power given to the Supreme Court, it is just for removing the mistakes. So after all these institutions are being run by human beings, so there can be mistakes. So in order to avoid if there is any errors, that's what is the aim behind this particular jurisdiction. So suppose if the Supreme Court made a judgment, so the Supreme Court will revise that particular judgment maybe once, twice or thrice as much as they want. This is just for removing if any kind of errors had taken place in the judgment that might have crept in the judgment or order. So that can be some possibilities for happening mistakes. In order to avoid those kinds of mistakes, the Supreme Court has the power to use its revisory jurisdiction. And there is a particular reason behind it, because the verdicts of the Supreme Court or the judgments of Supreme Court is a court of record, and the other subordinate courts will be referring to the judgments and verdicts of the Supreme Court. Okay, its decision cannot be questioned in any court. Suppose in a case, if Supreme Court made a wrong judgment, in a lower court it will be questioned, and it will be resulting in losing the superiority or power of the Supreme Court. So it must not happen. With this concern, and the Constitution, Article 137 empowered the Supreme Court to review any judgment or order made by the Supreme Court. So these are the two different type of jurisdictions which we have discussed today. First one, advisory jurisdiction, and second one, revisory jurisdiction. So dear students, I hope that you have got a clear idea about these two different points. With this, we are winding up today's class, and in the next class we will be discussing about judicial review. So with the new topic, we will meet in the next class. Till then, I would like to sign off. Thank you.